Did you know that there are 7 hidden traps that could lead to the revocation of your United States citizenship, even if you were born in America or have been a naturalized citizen for decades? These traps are often overlooked, misunderstood, or simply unknown to most citizens. And falling into any one of them could result in losing your citizenship, your passport being canceled, and potentially even being deported from the country you call home. Whether you're a naturalized citizen, a dual citizen, or even a natural born American, these hidden dangers could affect you. And the consequences are far more serious than most people realize. This isn't fear mongering or exaggeration. These are real legal provisions that have been used to strip citizenship from thousands of people over the years. And in the current political climate, enforcement of these laws has become more aggressive than ever before. Welcome back to U.S. Immigration Desk, your most trusted and comprehensive source for critical information about immigration, citizenship, visas, green cards, legal rights, policy updates, and everything that affects your status and security in the United States. I'm here today to break down these 7 hidden traps that can actually revoke your U.S. citizenship, explain the detailed legal framework behind each one, show you real-world examples of people who have lost their citizenship and had their lives completely turned upside down, tell you about recent policy changes and enforcement priorities that have made denaturalization more common in recent years, and most importantly, give you exactly what you need to do to protect yourself and avoid these dangerous pitfalls that could destroy everything you've built in America. If you're a U.S. citizen or in the process of becoming one, if you're a green card holder planning to naturalize, or if you're helping family members navigate the citizenship process, this video is absolutely essential viewing. So make sure you watch until the very end, because I'll also be sharing important legal resources, specific steps you can take right now to safeguard your citizenship, and warning signs that might indicate you're at risk. Don't forget to subscribe to U.S. Immigration Desk and hit that notification bell so you never miss critical updates like this that could protect your legal status and your future in America. Let's dive straight into the first hidden trap that can revoke your citizenship. And this one catches many people completely off guard because they think once they become citizens, their past can't come back to haunt them. The first trap is committing fraud or willful misrepresentation during the naturalization process or even during earlier immigration applications. This might sound obvious on the surface, but what many people don't realize is just how broadly this is interpreted, how minor the misrepresentation can be and still trigger denaturalization, and how far back the government can go to investigate your application and uncover discrepancies. If you became a naturalized U.S. citizen and the government later discovers that you lied, omitted important information, or provided false documents during your citizenship application, or even during your green card application, your work visa application, or any other immigration benefit you received years or even decades earlier, they can denaturalize you, which means completely stripping you of your citizenship as if it never existed. This isn't just about major lies like using a fake identity, claiming to be someone you're not, or using fraudulent documents to enter the country. It can include what many people consider seemingly minor things, like failing to disclose a previous marriage that ended in divorce, not mentioning a criminal record from another country because you thought it didn't count or was expugned, not listing all your children, including those from previous relationships, claiming you were physically present in the U.S. when you were actually traveling abroad for extended periods, lying about your employment history or the nature of your work, failing to disclose membership in certain organizations, including political parties or social groups, or even small discrepancies in dates or addresses that the government interprets as intentional misrepresentation rather than honest mistakes. The U.S. Citizenship and Immigration Services, known as USCIS, has been aggressively pursuing denaturalization cases in recent years with unprecedented vigor and resources. They've created special denaturalization task forces, dedicated entire departments and teams of lawyers specifically to finding naturalized citizens who may have committed fraud during their applications, partnered with other federal agencies, including the FBI and Department of Homeland Security, to share information and investigative resources, and allocated millions of dollars in funding to these efforts. They use advanced technology, including sophisticated database matching software that can compare information across multiple government systems, facial recognition technology to detect identity fraud, cooperation with foreign governments to verify information about criminal records and other background details, and data analytics to identify patterns that might indicate fraud. These investigations can uncover discrepancies that might not have been caught during the original application process years ago when technology was less advanced and background checks were less thorough. What's particularly frightening is that there's no statute of limitations on denaturalization for fraud. The government can come after you 10, 20, 30, or even 40 years after you naturalized if they discover evidence of misrepresentation. And by that time, you might have lived your entire adult life as an American citizen, raised children who are citizens, built a career, bought a home, and established deep roots in your community, only to have it all taken away. The emotional, financial, and social devastation of losing citizenship after decades can be absolutely overwhelming for individuals and their families. The second trap involves serving in a foreign military without permission. And this is an area where many dual citizens get into serious trouble without even realizing they're putting their US citizenship at risk. Many dual citizens or naturalized Americans don't realize that serving in the armed forces of a foreign country can be grounds for losing US citizenship, especially if that foreign military is engaged in hostilities against the United States, or if you serve as a commissioned or non-commissioned officer in a leadership position. U.S. law specifically states that if you voluntarily and with the intention of relinquishing U.S. citizenship serve in the armed forces of a foreign state engaged in hostilities against the United States, you can and will lose your citizenship automatically. But here's where it gets tricky, complicated, and where many people get caught in situations they never anticipated. Even serving in the military of a friendly nation, a close ally of the United States, can sometimes be problematic and raise questions about your citizenship if you didn't get prior written approval from the State Department, which most people don't even know is a requirement. For example, if you're a dual citizen of the US and Israel and you serve in the Israeli Defense Forces, which is actually quite common among dual nationals and is even encouraged by some communities, this could potentially be an issue depending on the specific circumstances of your service, your rank, whether you volunteered or were drafted, and whether you took an oath that included language about renouncing other allegiances. The same situation applies to people with dual citizenship in countries like South Korea, which has mandatory military service for all male citizens and doesn't provide exemptions even for those who also hold American citizenship, or Turkey, Greece, Finland, Switzerland, Singapore, or many other countries around the world that require military service from their citizens. The key factors that determine whether you'll lose your citizenship are whether you served voluntarily or were compelled by the laws of that country, whether you held a commission or officer position, which suggests a deeper commitment and leadership role, whether the foreign military was engaged in hostilities against the US or its allies at the time of your service, whether you took an oath of allegiance that included renouncing your US citizenship or promising loyalty to another nation above America, and critically, whether you had the specific intent to give up your US citizenship by serving. Most people who serve in allied militaries, especially if they were drafted rather than volunteering, and if they serve in regular enlisted positions rather than as officers, don't lose their citizenship. But it's a gray area filled with uncertainty that has caused problems for some people. The safest approach is to seek guidance from the State Department before serving in any foreign military, and to document that you're doing so under compulsion of foreign law and without any intent to relinquish your American citizenship. The third hidden trap is taking an oath or declaration of allegiance to a foreign country, and this is particularly relevant and potentially problematic for dual citizens or people who maintain strong ties to their country of origin through family, property, business interests, or cultural identity. If you formally swear allegiance to another country, especially if that oath includes explicit language renouncing allegiance to the United States, or if you make public declarations that suggest your primary loyalty is to another nation rather than to America, you could be considered under U.S. law to have voluntarily relinquished your U.S. citizenship. This has happened in numerous documented cases where naturalized U.S. citizens have returned to their home countries for various reasons and taken government positions, political offices, or other roles that required them to swear a formal oath of allegiance to that nation. It's also come up in cases where people have sought to reclaim or reacquire citizenship in their birth country after having given it up to become Americans, and they went through a formal naturalization ceremony in that other country that included pledging allegiance to that nation and explicitly renouncing all other allegiances. The critical legal element here is intent, which can be very difficult to prove or disprove. The government must prove that you specifically intended to give up your U.S. citizenship by taking that foreign oath. But proving what was in someone's mind at a particular moment is inherently challenging. However, certain actions create what lawyers call a presumption of intent, meaning the law assumes you intended to give up your citizenship unless you can prove otherwise. Taking an oath to a foreign country, especially one that includes renunciation language, creates such a presumption. You could find yourself in lengthy, expensive, and extremely stressful legal battles trying to prove that you didn't intend to relinquish your American citizenship when you swore allegiance to another country. The fourth trap involves treason, attempting to overthrow the government, sedition, or engaging in acts of terrorism. And while this might seem extreme and unlikely to affect average law-abiding citizens, it's important to understand the scope of what the government considers these offenses and how broadly they can be applied, especially in the current climate of heightened security concerns. Treason is defined very specifically in the U.S. Constitution as levying war against the United States or giving aid and comfort to its enemies. If you're convicted of treason in a federal court, you will automatically and immediately lose your citizenship with no possibility of retaining it. But beyond that clear-cut case, there are numerous related offenses that can also result in loss of citizenship. If you attempt to overthrow the U.S. government by force or violence, if you engage in seditious conspiracy, which means conspiring to use force to oppose the authority of the government. If you advocate for the violent overthrow of the government through speeches or publications, or if you provide material support to terrorist organizations, even if you didn't know they were designated as terrorist groups, these can all be grounds for denaturalization proceedings. In the current global climate, with heightened concerns about domestic terrorism, foreign terrorist organizations, homegrown violent extremism, and national security threats from both abroad and within the country, the government has become much more aggressive, proactive, and unforgiving in pursuing these cases. There have been documented instances of naturalized citizens who sent money to organizations that they genuinely thought were legitimate charities doing humanitarian work, only to find out later that these organizations were designated by the U.S. government as terrorist groups or fronts for terrorist organizations. Even though they had no intent to support terrorism and thought they were helping refugees or building schools, they faced denaturalization proceedings. The standards of proof are high, and you typically need a criminal conviction first, but the penalties are severe and life-altering. The fifth hidden trap is demonstrating through your actions that you never truly intended to make the United States your permanent home when you applied for citizenship. If you naturalize as a U.S. citizen, but then immediately within weeks or months move back to your home country permanently and establish your primary residence there, never really building a life in America, and if the government can prove through evidence like tax returns showing you paid taxes primarily in the other country, property ownership records, children enrolled in schools abroad, professional licenses, family ties, employment records, and statements you've made to others that you never actually intended to make the United States your permanent home, they can potentially challenge your naturalization on the grounds that you obtained it fraudulently by lying about your intent. This is based on the naturalization requirement that applicants must intend to reside permanently in the United States. The law doesn't require you to actually live in the U.S. forever once you become a citizen. And many American citizens live abroad for perfectly legitimate reasons, including work assignments, caring for elderly parents, studying, or simply preferring to retire in another country. But what the law does require is that at the time you applied for citizenship and took the oath, you genuinely intended to make the United States your permanent home. The sixth trap involves failure to register for selective service if you're a male who is required to do so. And this is a requirement that shockingly many people are completely unaware of, forget about, or don't take seriously. And it can come back to cause devastating problems years or even decades later. If you're a male who becomes a permanent resident or who lives in the US in virtually any status between the ages of 18 and 26, you're required by federal law to register with the Selective Service System, which is the independent agency that maintains information about people who could potentially be drafted into military service if Congress ever authorizes a military draft in the future. This requirement applies to U.S. citizens, green card holders, and even most categories of non-immigrants who are living in the United States. Failure to register is not just an administrative oversight or a minor technicality that you can fix later. It's actually a federal crime punishable by up to 5 years in federal prison and fines of up to $250,000, though criminal prosecutions are rare. More commonly and more relevant to citizenship issues, failure to register can be used as evidence that you're not of good moral character, which is a fundamental and non-negotiable requirement for naturalization. If you naturalized without registering for selective service when you were required to do so, and you didn't disclose this failure on your naturalization application, or worse yet, you claimed you had registered when you actually hadn't, this could be grounds for denaturalization based on fraud, willful misrepresentation, or failure to meet the good moral character requirement. The seventh and perhaps most surprising trap is engaging in certain types of employment with foreign governments without obtaining proper authorization from the U.S. government in advance. If you accept what's legally termed a policy-level position in a foreign government without obtaining specific written permission from the U.S. Secretary of State before accepting the position, you could potentially lose your citizenship, even if the position is with a friendly allied country. This doesn't apply to all foreign government jobs. It specifically applies only to positions that involve formulating government policy, executing policy at high levels, or directly and substantially influencing how a foreign government operates. The law was originally designed to prevent dual citizens from holding high-level government positions in other countries where their loyalties might be divided between the United States and that other nation, where they might have serious conflicts of interest, or where they might have access to sensitive or classified information that could potentially harm U.S. national security interests. For example, if you're a dual U.S.-Canadian citizen and you accept a position as a cabinet minister in the Canadian government, such as Minister of Defense, Minister of Foreign Affairs, or Minister of Finance, or if you become a senior diplomatic official representing another country as an ambassador or consul, or if you take a high-ranking position in a foreign intelligence service, national security apparatus, or military leadership at the general or admiral level, this could potentially trigger loss of citizenship proceedings. Now that we've covered these 7 hidden traps in extensive detail, let's talk about what you need to know to protect yourself and what concrete steps you should take. First and foremost, if you're currently going through the naturalization process or planning to apply, absolute honesty and complete disclosure is critical. Disclose everything asked on the forms and in interviews. Even if you think it's minor, irrelevant from many years ago, or you're not sure if it counts, it's far better to disclose something that turns out not to matter than to hide something that could be discovered later and used as grounds for denaturalization. If you have any uncertainty about what to disclose, whether something counts as a crime, whether an organization membership matters, or how to answer questions truthfully, consult with an experienced immigration attorney before submitting your application. The cost of legal advice up front is minimal compared to losing your citizenship years later. Second, if you're a dual citizen or maintain strong ties to another country, be extremely careful about taking oaths, serving in foreign militaries, or accepting foreign government positions. Before doing these things, consult with an immigration lawyer who can advise you on potential implications. In many cases, there are ways to do these things without jeopardizing citizenship, but you need to follow proper procedures and sometimes get advanced approval. Third, if you're a male who immigrated or became a permanent resident between 18 and 26, make sure you're registered with Selective Service. Check your status at the Selective Service website, and if not registered and still within the age range, register immediately. If over 26 and never registered, consult an immigration attorney about how to handle this. Fourth, keep detailed records of your time in the United States, travel history, employment, addresses, and all immigration documentation. If questions arise about citizenship, comprehensive records can be crucial. Keep copies of all immigration applications, supporting documents, and correspondence with authorities. Store documents safely in both physical and digital formats. Fifth, be cautious about statements online or offline that could be interpreted as supporting terrorism, advocating government overthrow, or expressing allegiance to foreign powers over the US. Everything you post on social media, emails, and public statements can be used against you. While you can criticize the government and express political opinions as protected rights, certain statements involving violence or supporting terrorist organizations can have serious consequences. If you receive notice of denaturalization proceedings, take it extremely seriously and hire an experienced immigration attorney immediately. These cases are complex with incredibly high stakes, and you need professional representation. Don't handle it yourself, ignore it, or wait for help. Understanding the burden of proof is important. The government must prove its case by clear and convincing evidence, a higher standard than most civil cases, though not as high as criminal cases. However, don't be complacent. The government has substantial resources, including databases, foreign government cooperation, and investigative tools to uncover decades-old information. Real-world examples show how serious these issues are. One man who was a citizen for over 20 years was denaturalized when the government discovered he failed to disclose a minor conviction from his home country on his green card application decades earlier. Despite living as a law-abiding citizen, raising a family, and building his life here, he lost everything. Another woman who naturalized was denaturalized for not disclosing brief foreign military service before coming to the US, even though it was short and non-combat. These cases demonstrate that the government takes these issues very seriously, and consequences can be devastating. Thank you so much for watching US Immigration Desk today. If you found this information valuable, eye-opening, and important, please give this video a thumbs up and share it with friends, family members, or anyone who might benefit from understanding these hidden traps that can revoke US citizenship. We're here every week bringing you critical information about immigration, citizenship, legal rights, benefits, and everything affecting your life and status in the United States. Subscribe to US Immigration Desk if you haven't already, and turn on notifications so you never miss important updates that could protect your legal status and future. Stay informed, protect your rights, know the law, and I'll see you in the next video. Take care and stay